in Georgia, where a man was arrested in the cold case murder of a University of Georgia law student. And this guy was fighting for bond, 48-year-old Edrick Faust, arrested earlier this year in the 2001 murder of law student Tara Baker. And firefighters discovered her body when they went to an apartment fire there, and they say that she was sodomized, she was strangled, and she was stabbed.
One, the science; two, the
True crime just got darker. Catch the full episode on the link above. Subscribe to At Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m.
Possess a lot of different variable characteristics. The ability to distinguish microscopically one person's hair from another is the basis for having a meaningful association or an elimination from a sample. So it's based on the fact that from a structural standpoint, hairs possess cuticles and the protein, the cortex, the middle part of the hair, medullary structures, all of which from a microscopic level are highly variable, but they are not variable to the extent of a absolute personal identification. Okay. It could be the possibility that two persons' hair could possess the same characteristics, but is highly variable within the population.
When you say medullary structures, do you mind explaining what a medullary structure is?
Sure. Inside the middle part of the hair, some people have open tubular air-filled gaps inside the middle of the hair. It's not clearly understood why that happens, but it could just be a space-saving biological feature that happens. But and not all people have a medullary structure in their hair. Some people have a lot. Some people have a variable amount of a little to a moderate amount. But it adds another important characteristic that's either it's there or not there. It can help distinguish one person from another person's hair.
Okay. And when you say variable characteristics, we've talked about medullary structures. What are some of the other variable characteristics that can be used to determine if a hair is consistent with a known sample or inconsistent with a known sample?
So there are other structures that are observable microscopically. For example, obviously pigment. You have different colorations of pigment and different sizes of pigment. What is the distribution of the pigment within the hair? Is it more towards the outer part, the inner part? Is it clumped? Is it separated particles? There are structures called corticofusi, small little air-filled gaps that can appear in the hair. There's also material called ovoid bodies, some kind of pigment-related clumps of pigment that can appear in hair. The extent and nature of them and the presence or absence are just other variabilities that help add characteristics that differentiate one person's hair from another.
And as it relates to those variable characteristics, are there some that are more common and some that are less common?
Yes, yes. So it is possible that some characteristics may be more highly distinctive than others. As an example, Caucasian hairs, very fine blonde hairs, would generally not have as many variabilities as a thicker, darkly pigmented hair would have, in general.
And so, I guess, as far as the process that you go through when you are going to conduct an analysis, I want to go to the procedure portion of hair analysis at this point. When you receive a submission from a law enforcement agency or however it gets to you, how is it that a hair analyst begins the process of analyzing a hair sample against a known sample?
So in the laboratory, we'd either receive a collected hair sample that's already in some type of container identified as collected from a particular location, or maybe a recovery where samples of hair are recovered within the laboratory and then isolated. The hairs are first mounted on a glass microscope, slide in a mounting media called per mount that enables the hair to be observed microscopically. They are looked at under a low-powered stereo microscope. Basically, it's a microscope that allows you to see things in more three-dimensional, as you would like normally have a vision and see objects, except these are at like around 10 to 40 times magnified. And you can look at the general characteristics of the hair, its length and thickness. So you can start categorizing a hair to potential racial origin, body origin, and just the observation of general features. And that way you can either easily include or exclude a hair for further testing. So hairs are often excluded as being dissimilar at that level. If they are not, they show similar characteristics at that level, they are then transferred to a comparison microscope. So a comparison microscope uses transmitted light to shine light through the hairs on a side-by-side basis. So there's actually two microscopes side by side. Optic bridge allows you to view both of the samples side by side. And now you're looking at the internal features, the pigment and the medullary structures at the present. All of the internal microscopic features are compared from the root, or what we call the proximal end of the hair, side by side, all the way to the distal or to the far end of the hair samples. Now, if those characteristics correspond along that way, that enables a conclusion that there is an association, that these hairs are consistent, and they could have originated from that person or another person possessing hair with the identical characteristics.
Okay. And as it relates to, and this is going to be particular to the GBI's processes after an examiner makes a determination that their analysis might have some probative evidence, is there any kind of peer review or confirmation process?
Yes. Any probative associations are reviewed by another qualified examiner. And then there's also a file review that would be done for a review of the notes and the report to see if they, reflect correct procedures were followed, and the right significance of note taking that supports that was also present.
Okay. And to your knowledge, the process that you described, is that the process that is generally accepted and recommended in the scientific community as it relates to hair analysis?
Yes, it is.
When you were working in part as a hair analyst for the GBI, is that the process that you applied when you would conduct hair analysis?
Yes.
Are you familiar with the case of involving a murder that occurred in Athens in January 19th of 2001, with the victim being Miss Tara Baker?
Yes.
All right. And did you have anything that you worked on in that case?
Yes, I produced several reports of evaluations I did on that case.
Is it related to the hair analysis that you did in that case? Did you follow the procedures that you've just outlined for the court in conducting that analysis?
Yes.
Okay. I'm going to hand you, after I show it to defense counsel, what I have marked as State's Exhibit 136. I'm actually going to go ahead and hand defense counsel 136 through 140. Peterson, I'm going to hand you 136 through 140. Go ahead and take a look at all of them, and then we'll start one by one after that.
Yes.
All right, and so, sir, starting with State's Exhibit 136, what is State's 136?
Stage 136 is a scientific report which I generated for this case. It follows case number 2001-1002454, which is the crime laboratory case number for the Tara Baker case.
And does this appear to be a true and accurate copy of the report that you generated?
Yes.
And what was the date of the report?
Report is dated February 2nd of 2001.
Judge, I move to tender 136.
Any objection? It is admitted.
State's Exhibit 137, what is that?
This is an official report that I generated on February 27th, 2001, regarding some hair examinations, again, under the case number laboratory 2001-1002454.
Does it appear to be a fair and accurate copy of that report that you generated?
Yes.
Judge, I move to tender 137.
Any objection? It is admitted.
State's 138, what is that?
An official report I generated on March 19th, 2001, again, under the case number 2001-1002454, generated, under the Tara Baker case number.
Does that appear to be a fair and accurate copy of the report that you generated in that case?
Yes, it is.
Okay. Judge, I move to tender 138.
Any objection? It is admitted.
Will you give me the date of that report again?
See, March 19th of 2001.
Thank you, Mr. Peterson. As it relates to State's Exhibit 139, can you tell me what that is?
An official report, which I generated in May 16th of 2001 on the Tara Baker case, again, case 2001-1002454.
And does that appear to be a true and accurate copy of the report that you generated?
It is.
Judge, I move to tender 139.
Any objection?
No.
It is admitted.
140, what are we looking at there?
140, again, it's an official report, which I generated, and this has been October 11th of 2001 under case number 2001-1002454. Again, case generated under the Tara Baker examination.
And does that appear to be a true and accurate copy of your report?
It is.
Move to tender 140, Your Honor.
Any objection? It is admitted.
I'm going to hand you several boxes of slides at this point, and they've all previously been admitted into evidence. So I'm handing you State's Exhibits 114 through 122. Defense 31, as well as, I'm sorry, it's State's Exhibits 114 through 125, as well as Defense 31. And I'm just going to hand them to you all in this box right here.
Okay.
I'm going to give you a few minutes. Obviously, that's a number of exhibits to look through all of those. And you just let me know when you're done with that.
Okay.
Do you recognize those exhibits that I just handed to you?
Yes, these are boxes containing prepared microscope slides with mounted hair samples on them, all generated under the case number for the Tara Baker case 1002454.
And so do those exhibits contain some of the hairs that you analyzed in relation to this case?
Yes, these will be the work product examinations of the hair.
Okay. And you indicated that they were broken, some of them at least. Were they broken when you were analyzing them?
I'm not sure in the circumstance why any of the slides would have been broken, but I mean, they are glass slides, so it is possible. And if a slide were to break, it would be remounted. The hair would be removed and remounted.
And I probably asked that question poorly, and I apologize for that. While you were conducting your analysis, was the slide broken while you were trying to analyze? Like, as in while you were looking at it, was the slide broken or not broken?
No, it would have been unbroken.
Okay. And so I want to start with your report in State's Exhibit 136. If you could, please explain on February 2nd of 2001, what items were you asked to analyze and what were your findings?
Well, there is a listing for item 2. That is, these are items listed under specifically the case number with a description of the sexual assault collection kit taken from Tara Baker. There were question hairs recovered from the buttocks of the victim, the torso of the victim, the left hand of the victim, and there were also known head hair samples submitted from a Chris Melton, Christopher Hall, Jeff Hall, Ashley Peavy, and Valerie Lang.
Okay. And did you, when you analyzed those hairs, what were your findings as far as any consistencies or inconsistencies, as well as any hairs that may not have been suitable for comparison?
Right. So the examination of the pubic combings of the victim revealed that the hairs present were consistent microscopically with the victim's own hair. The hair from the buttocks, there was one head hair consistent with the victim's own hair. There were 2 hairs inconsistent with the known hair of the victim and several hairs that were unsuitable for comparison. And then additional examination of 2 hairs were associated with the known hair of Ashley Peavy that they revealed corresponding microscopic characteristics. At a later date, then there were 2 hairs, too small for microscopic examination that were later pieced together that could be compared and they were compared at a later report. Hair recovered from the torso. There were numerous head hairs consistent with the victim's own hair. There was 1 hair inconsistent with the victim's hair, which was further associated with the known hair of Valerie Lang.
Then I'm going to stop you right there. So the first set of results we talked about, that's item 8. Is that correct?
That's correct.
And where was item 8 recovered from?
Item 8 was hairs recovered from the victim's buttocks.
Okay. The second set of results that we talked about, item 9, where was item 9 recovered from?
Item 9 was identified as a question hair from the victim's torso.
Okay. As it relates to item 10, which is the next item that I believe we're going to talk about your analysis on, what is item 10?
Item 10 is question hairs identified as from the victim's left hand.
Did you say the victim's left hand?
Correct.
Okay. Were you able to compare item 10 against the known samples that had been provided to you?
Yes. So the results were that there were several head hairs and 1 pubic hair consistent with the victim's own hair.
And so you said consistent with the victim's own hair as far as the hairs in the left hand. Is that correct?
That's correct.
Did you have an opportunity to also compare item 10, the hairs in the victim's left hand, against the hairs? I'm going to start that question over again. Were you also able to compare the hairs in item 10, the hairs that were retrieved from the victim's left hand, to the known head hairs of Chris Melton?
Yes. So once the hairs are associated with the victim, they would have already been demonstrated that the other known hair samples submitted would have dissimilar characteristics.
And so as it relates specifically to Mr. Melton, what would that finding mean as it relates to item 10?
Well, they could not have originated from him.
Okay. State's Exhibit 137 has already been admitted into evidence. What is the date on that report again?
That would be February 27th of 2001.
Okay. And on that report, did you have occasion to analyze hairs that were recovered from a power transformer?
Yes.
And is that item 12?
Item 12, that's correct.
Okay. What was the result of your analysis on the hairs recovered from the power transformer?
The results are that there were 2 hairs unsuitable for comparison and 1 head hair suitable for comparison. And further examination of the head hair found that it was similar or could have originated from Chris Melton.
Okay. And Mr. Peterson, I don't believe at this time I intend to necessarily introduce any of the fiber or textile evidence, so we'll skip over States 138. As it relates to States 139, what was the date of that report?
That report is dated May 16th of 2001.
Okay. And what were you asked to do in that testing and analysis that you did? Well, actually, I'm sorry, Judge. I misread this report. I don't think that that's going to be information that's going to be admissible based on the court's previous rulings. I'm sorry. That's on me.
Is that something that's already been admitted?
It has been admitted, Your Honor, as far as the report for purposes of the Daubert hearing, but I don't believe that it would be admissible in front of the trial jury.
All right, thank you.
And Your Honor, I don't believe that the state would be seeking to introduce the evidence that was analyzed in State's Exhibit 1. I think it is something that could be admissible, and the witness has already testified to the fact that he used the same methodology in that analysis, but it does not have any analysis of Mr. Melton's hair associated with it. It was other individuals who were collected as elimination samples and some hairs out of a drain assembly. So I'm not going to ask Mr. Peterson about States 140 at this time.
All right.
Judge, I don't have any other questions for Mr. Peterson at this time.
All right, Mr. Cruz, cross-examination.
morning.
Council, let me, can I see y'all at the bench for just a minute before Mr. Cruz gets started? Can I get your preference? Just a moment, no testimony is going to be taken. Deputy, good morning. Would you please have the jury come in and we'll have them go into the jury room and then we can give them their menus. They can look over that, but we're going to do that for right now. Thank you, because they're here. Good morning, ladies and gentlemen. We're going to give you the menus for today and let you look those over. We'll be with you shortly. Thank you. And Mr. Terrell, do they have the menus for today? Do you have those? Do you have the menus for today for them to look over, or they have them? Okay, very excellent. Okay, very good. Thank you very much. All right, we are back on the record. Mr. Cruz, you have the floor.
Mr. Peterson, good morning. How are you?
Good morning.
My name is Attorney Amai Cruz. I have the privilege and honor of representing Mr. Faust. Is it okay if I ask you a couple of questions? Okay. Were you aware, or are you aware, of the United States Department of Justice, the FBI, the Innocence Project, and the National Association of Criminal Defense Lawyers report regarding microscopic hair analysis?
Yes.
Okay. And in that report, you would agree out of 268 microscopic hair analysis testimonies given, 96% of those testimonies were deemed to be erroneous. Is that correct?
I'm aware that the report states that. You know, the other parts of the report is that it's based only on testimony, and a subsequent report to that pointed out that there is no fault indicated in any of the testing, any of the procedural aspects of the comparison of hair, only that there were reports that reflected testimony that seemed to indicate that hair had a absolute or more
belong to a particular person.
A particular person, as opposed to it, you know, could be other person's hair with the same characteristics. So they felt that during their review that there were strongly worded testimonies that perhaps would have given a false indication of the strength of the hair.
And would you agree that the determination is that the proper testimony for a microscopic hair analysis would include inclusion, exclusion, or indeterminate?
Yeah, I would say that sounds reasonable.
Okay, that is fair. But the state, from my understanding, is asking you, and correct me if I say anything wrong, to make a personal identification of who certain hair belongs to. Is that right? Is that how you understand your testimony today?
No, the testimony is that the hairs are associated microscopically. So it states that the in an inclusion, the hair either originated from that person or another person who possesses hair with the same characteristics.
Okay. And will that be the limits of your testimony here today?
Yes.
That's my question, Your Honor.
Anything else, Mr. Yelman-Chili?
No, Judge.
All right. Anything from the defense?
Just argument.
All right. Mr. Yelman-Chili, you have the opening and closing.
Your Honor, I just reserve.
All right. Mr. Cruz? Well, we've had one. Yes. I don't know where it is. Thank you, Mr. Terrell.
Yeah, I think the case law across the country is pretty clear when it comes to microscopic hair analysis, especially regarding the Department of Justice's report regarding the personal identification of the hair. From what I understand, the testimony from Mr. Peterson is going to be is that, correct me if I say anything wrong, that the hair is still going to be identified as belonging to a particular individual, but just add the caption on the end, or individuals with similar characteristics of hair. Georgia has not addressed this issue specifically, but Georgia has cited cases that have addressed this issue specifically, particularly Crawford v. State, Supreme Court case of Georgia. The site is 278 Georgia 95, and I'm reading from footnote 10. And the site, and it's very important, the site is the most important thing, is CEG, and as the Honorable Court knows, it supports this proposition and example given. Scott v. State is one of the sites. It is 581 SO period 2D 887. And this is page 892 that Crawford is citing. This is a 1991 case that Crawford is citing. Crawford is 2004 to give the Honorable Court the date of that case. But it states, it is important to recognize that hair comparisons do not constitute a basis for positive personal identification. So our argument is to the Honorable Court, the science, we have no issue with the science. It's the conclusions that we have the issue with. The science is solid when it comes to, we have this hair, these are the characteristics of the hair. But as far as saying, hey, this is Mr. John Doe's hair, this is not Mr. John Doe's hair, the science isn't supported in that way. Crawford also states State v. Faircloth, and that's FAIRCLH, and that's 99, capital N period, capital C period, APP period, 685. And again, Crawford is a 2004 case, but it's citing a 1990 case from North Carolina. And it states, this is the cite from the North Carolina case. Unlike fingerprints, however, comparative microscopy of hair is not accepted as reliable evidence to positively identify a person. The case also cites State v. Butler, 24 Southwest 3rd, 21. And just to give the Honorable Court the proper information on this case, this case is still good law. It's citing a case from Missouri, it's still good law, but it was over a separate portion of the case was overruled. Okay, but this portion is still good law, at least at the time of this case. And what it states is, as the expert acknowledged in her testimony, and as the authoritative articles confirm, there is no scientific basis for testifying that a hair comes from a particular person. Your Honor, I think you've seen this yourself. I think it speaks volumes that the state did not attempt to introduce any articles. We had a Daubert hearing last night with Mr. Chris Bolden, and he at least made sure that he introduced some literature to support the proposition that what Ms. Lycombe was doing was somehow, some way supported by the science. Here, the reason no articles were supported, and of course the state has the burden, is because the articles that are out there, the error rate is as high as 96%. And that was the FBI report that I discussed with the Mr. Thank you, Mr. Peterson. With Mr. Peterson, but also as high as 67%, but on average, as high as 96%, but on average, a 67% error rate. So the science, as Mr. Peterson said, is good science. However, you can't take that science and make a conclusion. What it requires is mitochondrial DNA testing that follows up to confirm or exclude. The limitation that I'm asking for Mr. Peterson's testimony, because I'm not saying the science is junk science, I'm just asking that he's not allowed to testify that, hey, this hair belongs to Chris Melton, this hair belongs to Ashley Peavy, this hair belongs to John Doe, or whoever it may be, because the science doesn't support that, the literature doesn't support that, and the state has the burden. And the state hasn't presented anything to support, to show that this process is peer reviewed. They haven't brought in any evidence about the error rate. The only thing they focused on were the conclusions. And the conclusions in this case, and with microscopic hair analysis, the conclusions that positively identify a person is what's inadmissible, Your Honor. And that is our position. So we would just simply ask the Honorable Court to limit the testimony. We're on the same page as far as the science. The only issue in this Dauber hearing is the conclusions that could be made. We would ask that the conclusion is simply limited to, if you want to describe the characteristics of hair, and say exclusion, exclusion, or indeterminate. We have no issue with that.
Okay, Mr. Cruz, let me make sure I know what you're asking the court to do. So what it sounds like that you are not contesting the state's presentation of the requirements of 702. Is that right?
No. So that now in my argument, I'm saying that I don't contest the science, but the state still hasn't met their burden. So I want to make it clear. I'm not saying I agree to admission of this testimony. I'm just saying, as far as argument, I'm not arguing that the science is junk science.
Okay.
But the state hasn't met their burden to admit this argument. So I do want to make that clear.
Okay. All right. Well, that was my question.
Okay.
All right. So the second portion of your argument, though, is inconsistent with the hearing we're having right now. So I guess what I need to understand from you, just so I know what you're talking about, is that you are still contesting this expert's ability to testify in court.
Correct.
And are you also saying that if this witness is allowed to testify, that you want his testimony to be limited?
Correct.
Okay, so you're sort of asking for a motion in limine to some extent. Is that what you're asking for?
If that's the way
Okay.
it comes across, that's fine with me.
Okay, so you're really asking for two different things. You're asking the court to grant your motion with regard to 702. Is that right?
Correct.
Okay. But you're also asking that if the court does not grant your motion, you're asking the court to limit, in a motion in limine, this expert's testimony.
And just to make it clear,
Not say a conclusion as you have articulated.
correct. And we may
Okay.
be saying the same thing, Your Honor, but I understand it as that is a part of 702. It's the testimony that the state is seeking to admit. So I'm saying my understanding is I'm arguing under 702. The state hasn't met its burden to show the science is good science.
I understand.
But also, if the Honorable Court says, I disagree, we're asking the Honorable Court to limit the testimony because the state hasn't shown in any manner that the particular testimony that they're seeking to elicit from Dr. Peterson is admissible under 702.
Okay, and that's what I'm calling a motion in limine. But I understand what you're arguing now.
Yes, ma'am.
Thank you.
Thank you, Your Honor.
All right, Mr. Yellman-Chili, any closing?
Yes, Judge. As it relates to the science, am I understanding Mr. Cruz's argument to be that he is not challenging the validity of the science of hair analysis, correct?
I want to make it clear for the record. In closing for our conversation, I'm just advising the Honorable Court that I am not saying it's junk science, but I want to make this clear. I'm not consenting to this testimony. The entire scope of this hearing is for the state to meet its burden. So that's what I wanted the Honorable Court's ruling to focus on, whether or not the state met its burden to if the science should be admitted.
And I'm just asking so that I understand what I need to argue, because obviously if the body of science itself isn't being contested, then I can limit my argument to what I think the testimony was from Mr. Peterson regarding what his opinion would be.
The body of science is being contested to the extent that the state has to meet its burden of proof under 702.
Okay. All right. So, right. All right. I think I understand now. Your Honor, I'm going to hand Mr. Cruz as well as the court a couple of cases, and hopefully I'm not handing anybody my highlighted copy. And Your Honor, can I approach?
May?
I handed the court two cases. The first case is United States v. Brown. That is 415 F3D 1257. And then the next case is U.S. v. Barnes, which is 481 Federal Appendix 505. Brown is a 2005 11th Circuit case, and Barnes is a 2012 11th Circuit case. And they both stand in general terms for the fact that the court has broad discretion in its ability to review expert opinion evidence and determine whether or not it is admissible under 702, and in particular as it relates to Barnes, which is the 2012 11th Circuit case. If we go to the fourth page on the right side of that opinion, Your Honor, in section E, you will see a discussion of hair and fiber expert testimony that was elicited and admitted in that case. And then if you go forward to page 6 on the bottom of the right side, going into the top of page 7, the case discusses the Daubert factors and makes clear that that is not a those are things for the trial court to consider in its determination, but they're not factors that must all be met in order to allow the admissibility of evidence. The court is still able to exercise its discretion in determining whether or not evidence should be admitted. And that's certainly the case in situations where expert testimony is supported by science and is going to be helpful to the trier of fact in determining an issue. But the scientific field and the methodology used don't allow for quantification, but they are methodologies that are generally accepted within the scientific field. So I think that that touches specifically in Barnes quite explicitly on hair analysis. Again, that's a 2012 11th Circuit case. Obviously, as the court knows, the 11th Circuit is the circuit we look to when we're looking for rulings that can be helpful to Georgia courts when applying standards that have longer been standards in the federal system than they have in the Georgia system, whether that be the rules of evidence or whether it be shifting to the Daubert standard in 24/7/702 for the court's analysis of when to admit expert testimony. And so I think given those factors, as well as Mr. Peterson's testimony about the methodology used being scientifically accepted and his having applied it in his analysis in this particular case, I do believe that the state has met its burden.
That's actually a test Clarke County is doing this morning, just so everybody knows we're not under attack, I don't think. I certainly hope not, but that's my understanding. It was 9:30 and I realized that's what it was. So I got an email about it yesterday and I didn't think about it.
Would you like me to just wait till it's done or just keep going? I'm fine either way.
Let's just wait for a moment because it's just going in and out. So. Good to know our system works. We have a good emergency management notification system. I think you're good. I think you're good.
Thank you, Judge.
Go ahead.
As it relates to the method and or I guess the form of the opinion that Mr. Peterson would offer, I disagree with defense counsel's characterization of the response that Mr. Peterson offered. I think, in fact, the opinion that Mr. Peterson offered, as well as his response on cross-examination, is that he is not offering an opinion that an individual whose hair is deemed to be, and I'm going to look at the actual language from the opinion, consistent with the known head hair of a sample. It is not to say that that is exclusionary of every other person possible, similar to the way DNA evidence would be exclusionary to, a certain degree of mathematical certainty. In fact, he said the opposite of that, is that his opinion would be that it would be consistent with that individual or another individual who had those same characteristics in their hair. So I think that that is certainly the type of opinion that does not run afoul of some of the propositions that Mr. Cruz has stated to the court, and that his opinion as it relates to hairs that either consistent with the known hair of someone or someone else who has those same characteristics. Now, he said that if there is some opinions in his report that I'm interpreting his response as saying, this hair, this individual can be excluded as a source of this hair because the characteristics are inconsistent, and so we know we can exclude that person. And I think he mentioned some hairs that were not suitable for comparison. I don't know that we elicited any opinions about not being able to form either an inclusive or exclusionary opinion, but certainly there was no testimony, and in fact, testimony to the opposite of the idea that hair analysis could yield a quote unquote match that would be of the type that we would think of when we were thinking about DNA analysis. So I don't think that's the opinion that Mr. Peterson's indicated that he is going to offer. And I believe the opinion that he indicated he's going to offer is an opinion that Mr. Cruz in his argument said would be a valid opinion to offer in the field of hair analysis. So I'd ask the court to allow him to testify consistent with what he has represented his testimony would be in front of the jury. Thank you, Judge.
Thank you. All right, with regard to this particular witness, I've already deemed him an expert in the area of human hair analysis and textile and fiber analysis. I'm making a finding under the requirements for 24-7-702 that the state has, in fact, met its burden. With regard to number one, the expert scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. I think it is clear from the testimony and how Mr. Peterson explained what he analyzes, that testimony is not that which a layperson would know. With regard to number 2, the testimony is based upon sufficient facts or data. The testimony was that this expert's analysis was, let's see, conducted, let's see, sorry, I'm confusing my notes here. That his analysis is based upon sufficient facts or data. With regard to number 4, this expert has testified that he has reliably applied the principles and methods to the facts of this case. He has testified about the process. He has testified about the manner in which his analysis is reviewed, how that is consistent with his tenure at the GBI, that it is accepted in the scientific community, that his methodology is scientific, and that he also used the processes that he described in analyzing the evidence in this particular case. And so I believe, based on the evidence that the state has presented through Mr. Peterson, that they have met their burden under Daubert. With regard to the motion in limine, the reason that I'm going to deny your motion, Mr. Cruz, is because it is not necessary. It is clear that this expert is not going to testify in the manner that you're asking for him not to. That his testimony is one of either consistency or elimination, but his testimony has not indicated that he is commenting on his analysis in the way that you were asking the court to exclude it. And so I'm just making a recognition of that. I don't think it is necessary. Should it become necessary, I'll have a hearing outside the presence of the jury and we'll discuss it. But that certainly has not been the case in the hearing this morning. So I'm going to deny your motion with regard to 702 and this particular witness. All right. Is there anything we need to take up? We're going to take a quick break and then bring the jury out. Ask the state first. Anything we need to talk about before we get started?
No, Judge.
All right, Mr. Cruz, anything, sir?
No, Your Honor.
All right, very good. We are going to take a 5-minute recess and then we'll bring the jury in. Thank you.
So you don't. Why would they put money?
Well, they're gonna put it.
is on a short break. Don't go anywhere. The action will be right back on at Southern Sin. You're watching at Southern Sin, your home for true crime. Court will begin shortly. Don't go anywhere. Subscribe to at Southern Sin and hit the bell for when we go live.
Just because I couldn't find any good information for him. But I bumped into him into the courthouse, and I'm assuming that they have an objection to it, but we're going to amend our witness list tonight, provide state notice of his information. I just got his information, which would allow us to bring him in during our case in chief. But I do think because it's in the middle of trial and it's kind of the last minute, it's something that does need to be brought to the attention of the court, just so the honorable court to decide if this is something the honorable court would allow or not allow, and that would determine our preparations.
All right. Thank you, Mr. Yellowman-Shirley.
I guess one of the first questions would be, who is it? And as far as a determination for the court, what would this person testify to? I don't know that not having contact information is grounds for not including somebody on a witness list. If it's newly discovered information, that's a separate thing. But before the state takes a position, I just would need some more information as well.
All right. At this point, I'm not going to allow another witness on the witness list. The witness lists have been out for a long time. They have been subject to amendment before we began this trial. If it was somebody that either side knew that they wanted to testify, even if they couldn't find them, that person needed to be included. The jury, the entire jury pool, but particularly the jury that has been seated, they were all asked questions about whether they were related by blood or by marriage to all of the witnesses in this case. And that would not have been done for this particular edition. And so I'm not going to allow it. All right. Anything else before we bring the jury in?
I just would like to get a sense of the court's preference. Our next witness is going to be Ms. Lacan, who testified last night. Right. Certain exhibits were admitted during that Dahlberg hearing last night. It would be the state's preference to just use the same exhibit number just for, and I don't know that.
I mean, I think the same exhibit number is appropriate. Mr. Cruz made it very clear, unless you tell me otherwise, it was admitted for the purpose of that hearing only. So you'll go through the same process if you want to, about admission of evidence, if you want to admit those. But I think the numbers need to stay the same.
That's what I thought too, Your Honor. I just want to be clear before I started putting stickers on things.
Okay, very good. Thank you. All right, anything else?
And Judge, this is kind of in that same vein as it's going to relate to Mr. Peterson's testimony. The copies of his reports that I admitted during the Dahlberg hearing are not redacted. And so would the court want me to redact what's already been admitted prior to it being shown to the jury or handed to the witness? Or would you like me to leave it in its actual form as it was admitted during the Dahlberg hearing?
I'm not sure I understand what you're saying. Are there portions of the evidence that you admitted during the hearing that need to be redacted?
Yes, Judge.
Okay.
In accordance with the court's ruling on the state SODY motion, some of the information listed as far as suspect or some of the elimination samples that aren't actually relevant to the trial of the case.
Sure. I would say this as a general rule, Mr. Cruz, you certainly can respond before I say anything about what he's referring to. Anything you'd like to add?
No, ma'am.
Okay. Thank you. So I would say, Mr. Yalamanchili, for efficiency purposes, that it would be imperative to redact what is appropriate to redact before you tender it. And I think that's the best way to handle it, as opposed to after.
Yes, Judge.
All right.
Happy to do so.
All right, very good. And you can show, obviously, Mr. Cruz, what you're redacting. If you have any objection to that, obviously we'll take it up before it gets admitted or is offered for admission. But
Thank you, Your Honor.
thank you, Mr. Cruz. Anything before the jury comes in? All right, thank you. You may bring the jury in. All right, everyone may be seated. Thank you. Good morning, ladies and gentlemen. We are back here in court today with regard to State of Georgia versus Edrick Faust, SU 24 CR 0547. I appreciate you all arriving here on time, as usual. I just want to let you all know that we are starting late today, and I promised you that we would be as efficient as we could, and we are actually keeping to that promise. It may not seem like it because we're starting late. I just want to explain to all of you. We were here late last night, handling some matters, of course, that needed to be done outside your presence. The attorneys were here really late. We knew we needed to be here today, to handle some other matters outside your presence. I didn't have it in my heart to make them come in at 8 o'clock because it was a long day yesterday and we were here really late. So we got here at 8:30 and started right away. And obviously we weren't finished until now. So I just want you to know we're not wasting your time and chatting about things that, we don't need to be chatting about. I just want you to know we've been working very hard to get through some things so we can get started. I appreciate you all filling out the lunch menus. Of course, we're doing that again today because we have an early day today, and I just want to get through things as much as we can. On Monday, we'll go back to kind of a regular schedule, and we'll have a regular lunch hour. You all can leave and stretch your legs and get some fresh air and things of that nature. And so I just wanted to make sure you're aware of that. All right, we're going to get started. Is the state ready to proceed?
State's ready, Your Honor.
Is the defense ready?
Yes, Your Honor.
All right, thank you. You may call your next witness.
Marissa Lacan.
Could you get Marissa Lacan, please?
Ma'am, if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name and spell it for the court reporter?
Marissa Lacan, and it's spelled Marissa. Last name is Licon.
Ma'am, how are you employed?
I'm employed at Pure Gold Forensics.
How long have you been employed at Pure Gold Forensics?
Since May of 2022, so approximately 3.5 years.
And tell us a little bit about Pure Gold Forensics. What is it?
We're a private accredited forensic DNA testing lab located in Southern California.
What kind of testing does Pure Gold do? Generally speaking.
So we do serology as well as DNA testing for prosecution, defense, as well as private parties.
What is your position at Pure Gold Forensics?
I'm a forensic scientist.
Can you please explain what your job entails?
So it involves serology testing as well as DNA testing using Global Filer as well as Y-Filer amplification kits. I analyze mixtures using StarMix probabilistic genotyping software, interpret the data, and producing a scientific report based on the data.
Can you talk a little bit about your educational background?
I have a bachelor's of science degree in forensic chemistry with a concentration in criminalistics.
And other than the education that you received in obtaining that degree, is there any other training or experience that you have that has assisted you in your work as a forensic scientist?
Yes, so upon being hired at the lab, I underwent their training program. So it was approximately a year and a half total. I was first trained in serology, which is the identification of body fluids. I underwent an observation period in which I watched another analyst perform the testing, a practical period in which I performed the testing on mock samples. I completed a oral as well as a written exam, and then completed and passed a competency test. I was observed on 3 cases before I was signed off to do independent casework in August of 2022. Subsequently, I was trained in DNA analysis, in which I also underwent an observation period, a practical period, where I performed testing on mock samples using different extraction methods. I completed my own sensitivity as well as mixture studies. I completed and passed 2 competency tests, as well as 2 moot courts, and completed an external 4-day StarMix training. And
ma'am, are you a member of any professional organizations?
Yes, I'm an affiliate member of California Association of Criminalists, as well as a professional affiliate member of American Academy of Forensic Sciences.
And ma'am, outside of this case, prior to coming to Athens, have you ever testified as an expert in court before?
Once.
And where was that?
In Colorado.
And what was the nature of that testimony?
DNA testing.
Your Honor, at this time, the state would ask that Ms. Lacan be permitted to testify as an expert in forensic chemistry and forensic biology.
Any objection from the defense?
Based on honorable court's prior ruling.
All right. This witness is declared an expert in the areas of forensic chemistry and forensic biology. You may proceed.
Thank you, Your Honor. Ma'am, back in 2024, was Pure Gold Forensics asked to perform certain serology testing on 2 items of evidence submitted from the GBI crime lab?
Yes.
What items did you receive from the GBI?
We received 2 items, which were apparent cuttings of swabs.
How were those items submitted to your lab?
We received them via FedEx.
Okay.
So, I'm going to hand you an item that's been labeled, I believe, States 141. Is that right?
Correct.
Okay. And what is States 141?
It's the envelope we received.
And how do you recognize that envelope, ma'am?
This is the envelope I opened and tested the items inside.
And does your initials appear on that item?
Yes.
In what condition was States 141 when you received it at Pure Gold Forensics? Was it sealed? Let me ask.
Yes, it was sealed.
Okay. I'd move to tender States 141, Your Honor.
Any objection, Mr. Cruz? It is admitted.
Ms. Lacan, inside States 141, are there a number of items in there?
Yes.
Okay. Can you take those out? Okay. States 142, what is that?
This is Georgia Bureau of Investigation, their evidence transfer receipt.
Was that, again, located inside States 141 when you received it at Pure Gold?
Yes.
And in fact, as going back to States 141, was that item completely sealed until just a few minutes ago right outside of court?
Yes.
And did you witness it being opened prior to coming in and testifying?
Yes.
Okay. States 142, what is that?
That's the transfer receipt.
Oh, I'm sorry, 143. Pardon me.
This is an envelope labeled cuttings of item 2I, oral swabbings B.
Okay. And 144, what is that?
A sealed envelope labeled cuttings of item 2J, oral swabbings A.
And just again to clarify, when you received States 141, were 142, 143, and 144 all contained inside of it?
Yes.
Do you recognize, especially as it relates to 143 and 144, those items as having your initials on them?
Yes.
At this time, I'd move to tender States 142, 43, and 44.
Any objection, Mr. Cruz?
No, Your Honor.
They are admitted. You may.
Ms. Lacan, based on the request, as you might have understood it from the GBI Crime Lab, what, if any, tests did you believe may be relevant in making any determination as to the potential biological source of the items of evidence that were contained in States 143 and 144?
We were requested to perform saliva testing as well as vaginal epithelial cell testing. So I determined that our RSID saliva test, as well as our Lugol's iodine tests, presumptive for vaginal epithelial cells, were appropriate.
Let's start with the RSID saliva test that you just described. Briefly, ma'am, what is amylase?
It's an enzyme found in saliva.
Okay. And where is amylase primarily found in the human body?
In the mouth, saliva.
How does the RSID saliva test test for the presence of amylase in a biological sample?
So it's a lateral flow test strip. So essentially you have your sample that's been extracted and you combine it with a buffer that comes with the test kit. And then you deposit that onto a cassette that has a membrane that contains antibodies that are specific for the antigen, which in this case is the alpha amylase from saliva. And when you deposit your sample, if the alpha amylase is present, the antibodies will capture it, and it'll continue down the membrane. And a positive test will result in 2 visible lines, and a negative test will result in a singular line.
Does it kind of resemble like a COVID test?
Yes, or like an at-home pregnancy test.
What does RSID stand for?
Rapid stain identification.
Oh, you mentioned that. I just want to be clear. Has the RSID saliva test been validated as an appropriate test for detecting the presence of saliva at Pure Gold Forensics?
Yes, we complete our own internal validation.
And has Pure Gold Forensics tested for the sensitivity of the RSID saliva test?
Yes, so during our validation, we tested different dilutions of saliva, and we came to the conclusion that the RSID saliva test kit can detect as little as 10 nanoliters of saliva, and so there's 1 million nanoliters in 1 milliliter.
So that a significantly small amount of
Yes.
sample. Okay. Can the RSID saliva test yield false positive results?
There are other biological fluids that can yield false positives, such as human breast milk, fecal matter, and high concentrations of sweat.
And when we say false positive, just to be clear, what exactly does that mean?
Another substance that can give a positive test, but it's not the specific substance you're testing for.
And based on the possibility of a false positive result, is the RSID saliva test only considered a presumptive test rather than a confirmatory test for the presence of saliva?
Yes.
And can you just kind of explain for the jury what we mean by presumptive test versus confirmatory test?
So a presumptive test gives the likely presence of a substance, but due to false positives, it's not a definitive yes or no, whereas a confirmatory test is highly specific and can give a definitive yes or no, this substance is present.
Ma'am, to your knowledge, is there a confirmatory test regarding whether or not a sample of biological evidence is positive for the presence of saliva?
No.
And is the RSID saliva test generally accepted in the scientific community as a presumptive test for the presence of saliva?
Yes.
I want to shift gears a little bit and talk about Lugol iodine. What is the Lugol iodine test designed to look for?
It's designed to look for glycogen.
Before we get into glycogen, let's talk a little bit about epithelial cells. What is an epithelial cell?
It's a skin cell.
Okay. And can epithelial cells come from all over the human body?
Yes.
Can you please describe, generally speaking, the science behind the Lugol iodine test?
Yeah, so the premise behind the test is that the glycogen content of vaginal epithelial cells is extremely high between a woman's first menstruation and menopause. So when these cells are stained with the Lugol's iodine, they'll exhibit a dark chocolate brown color. There are other areas of the body that do contain glycogenated cells, such as oral secretions, as well as the urethral opening of the penis. However, the glycogen content of these areas is less abundant. So based on our validation as well as studies, we use a 10% threshold that if more than 10% of the cells stain the dark chocolate brown color, it's considered a positive indication for vaginal epithelial cells.
And ma'am, I think you might have hinted at this just now, but can you explain a little bit about why the Lugol iodine test might yield different results on a sample collected from a vaginal swab versus a sample collected from an oral swab?
Yeah, so amylase that was mentioned earlier that's present in saliva breaks down glycogen. So that's why there's a less abundant amount of glycogen in oral secretions.
And again, I think you might have answered this a minute ago as well, but is there a generally accepted percentage of chocolate stained cells that one might observe which would indicate that a sample was collected from a vaginal swab?
Yes, we use a 10%.
And is that percentage higher or lower than others may have accounted for?
Yeah, so there's a study that examined buccal cells versus vaginal epithelial cells. And they determined that with a water extraction and mechanical shaking of the sample, actually less than 1% of oral secretions will stain the chocolate brown color. So our 10% threshold is more conservative.
Is the Lugol iodine test validated by Pure Gold Forensics as a presumptive test for the presence of vaginal epithelial cells?
Yes.
And to your knowledge, is there such thing as a confirmatory test for the presence of vaginal epithelial cells?
No.
Ma'am, when you received what we've tendered into evidence as states 143 and 144, these are the samples of cuttings, is that right?
Yes.
Please describe the process by which you undertook the testing that you performed.
So I first reviewed the case file, and then I removed the evidence from our evidence storage, took it into the evidence examination room where I opened it, took photos, took notes of it, and then I took it for our extraction procedure. It's our analytical procedure 5, which is a general extraction procedure that allows the analyst to retain the substrate, take the liquid portion for serology testing, and then take the cell pellet portion for either DNA extraction or microscopic examination.
Okay. And once you did all that, did you perform both the RSID saliva test and the Lugol iodine test on each item?
Yes, I did.
Okay. And just to be clear, when we're talking about the Lugol iodine test, how are you looking for or observing those chocolate stained cells that you just described earlier?
The process of putting them on the slide.
Yes.
So it goes back to the extraction procedure. So I take the substrates, which in this case were the apparent cuttings of swabs, and I place them into a test tube along with sterile water. We allow it to incubate for approximately 30 to 60 minutes. And during that time period, we vortex it several times, which means to shake vigorously. We do that by putting it on a machine. When that time period has passed, we centrifuge, we take the substrate and we put it into a spin basket on top of the same tube, and then we centrifuge the tube extremely fast so it spins fast, which pulls the liquid from the substrate. At this same time, it causes the cells within the sample to pellet at the bottom of the tube. So when that's done, we remove the spin basket, place it into a separate tube, and then left in the tube, we have the liquid portion as well as the cell pellet. We pull off the majority of the liquid portion and then place that into a separate tube. That's what we refer to as the supernatant, which can be used for the different serology tests, so body fluid identification. And then left in the original tube, we have the cell pellet along with a small amount of liquid. So to get to the microscopic exam part, we vortex the cell pellet along with the liquid, and then we take a small amount, so 2 to 10 microliters, and we place it onto a slide, heat fix it, and then we stain it with the Lugol's iodine.
Thank you. And again, I want to talk about the testing results specifically related to states 143, which is your item number 1, labeled as cuttings of item 2I, oral swabbings B. That's super confusing. As it relates to this particular piece of evidence, regarding the RSID saliva test, what was your result?
It was positive for RSID saliva.
Objection. I believe that exceeds the scope of the honorable court's ruling in regards to Dauber yesterday, if I'm not mistaken. I believe that testimony that we just received exceeded the scope of the testimony expected from the Dauber.
Mr. Bolden, any response?
I mean, the fact that it's positive, I think the witness has established that that's not a confirmatory test, it's just a presumptive test.
Yeah. If that's in the form of an objection, I'm going to overrule the objection. Go ahead.
If I can approach, Your Honor?
You may.
going to show you what's been marked as States 145. Do you recognize that?
Yes.
What is States 145?
It's the RSID saliva cassette testing results from our item number 1.
Okay. And does that picture fairly and accurately depict the results of the test on the cassette?
Yes.
Contender States 145, Your Honor.
Any objection?
No, ma'am.
It is admitted.
And Mr. Khan, did Pure Gold actually retain the cassette itself?
No, as long as we take a photo of it, we throw it away after.
With regard to the Lugol iodine test on States 143, what were your results on that, ma'am?
It was negative for the presumptive presence of vaginal epithelial cells.
And did you take a photograph of the microscopic slide that led you to that conclusion?
Yes.
If I can approach again, Your Honor.
You may.
It's going to get really confusing because we're going out of order. This is States 134. You recognize that?
Yes.
What is States 134?
A field of view from the microscope slide from our item number 1.
Is that a fair and accurate depiction of the slide as you observed it when you conducted the Lugol iodine test on that piece of evidence?
Yes.
The contender States 134.
Any objection?
No, ma'am.
It is admitted.
Your Honor, if I could publish
All right.
145 and 134 to the jury at this time.
Are you going to do it on the machine?
Yes, ma'am.
It is on.
Thank you. All right, we're going to start with States 145. Ms. Lacan, again, what is this?
This is RSID saliva cassette testing results from our item number 1.
You indicated that that was positive test.
Yes, it's positive.
And how do we know that?
With the visible 2 lines.
States 134, again, is that the picture of the microscopic slide after performing the Lugol iodine test on States 143?
Yes.
Okay. What are we seeing here?
We're seeing yellow staining. So epithelial cells that are not glycogenated will exhibit a yellow or no staining.
And so again, with the Lugol iodine tests, what was the result of that, if I didn't ask?
It was negative for the indication of vaginal epithelial cells.
All right, we're going to shift gears now to States 144. With regard to this piece of evidence, again, just to be clear, did you perform both the RSID saliva test and the Lugol iodine test on the cuttings from this item, ma'am?
Yes, I did.
Okay. And as it relates to the RSID saliva test, what was your result?
It was a negative RSID saliva test. No indications of saliva were detected.
If I can approach, Ron?
You may.
On this is States 146. You recognize that?
Yes.
Is that a fair and accurate portrayal of the cassette in which you performed the RSID saliva test on States 144?
Yes.
I move tenders States 146 at this time.
Any objection?
Okay.
It is admitted.
And did you also perform the Lugol iodine test on States 144?
Yes.
And what was the result of that test?
Greater than 10% of the cells stained the chocolate brown color, so the indication of vaginal epithelial cells were indicated.
And like before, did you take a picture of the slide with which you made that determination?
Yes, I did.
If I can approach one more time.
May?
This is states 135. You recognize that?
Yes.
Is that a true and accurate depiction of the slide that you created and observed after running the Lugol iodine test on states 144?
Yes.
Any objection? It is admitted.
And if I could publish these to the jury.
You may.
All right, this is 146. Again, is that just, oh, that's upside down. Is that the RSID saliva cassette that you used in examining states 144?
Yes.
And it just, again, to be clear, what was the indication on that test?
The
Positive or negative?
negative.
And how are we seeing that here?
There's only a singular line at the control line and not a line at the test line.
States 135. And again, just to be clear, is this the picture of the microscopic slide after running the Lugol iodine test on states 144?
Yes.
And what are we seeing here?
We're seeing greater than 10% of the cells have exhibited a chocolate brown staining. So that's why it was considered a positive indication.
Based on your training and experience, coupled with the results of the testing that you performed on states 143, which is GBI item 2I, that testing to include both the RSID saliva test and the Lugol iodine test. If I were to tell you that that sample came from an oral swab, would that be consistent with your findings?
Yes.
As it relates to states 144, your item number 2, GBI item 2J, again, based on your training and experience, coupled with the results of the testing that you performed on this piece of evidence to include both RSID saliva and Lugol iodine, if I were to tell you that this sample came from a vaginal swab, would that be consistent with your findings?
Yes.
And lastly, in connection with all the testing that you've described here this morning and the slides and cassettes that we've all gone over, did you have an opportunity to prepare a report that summarized those findings?
Yes.
Back in approach, Ron.
You may.
All right, this has been marked states 133. Is that just a copy of the report that you generated in connection with this case?
Yes.
I move to tender states 133.
Any objection?
Hearsay.
Any response to the objection of hearsay?
There you go.
It is overruled and admitted with your objection.
Ma'am, those are all the questions that I have for you. The defense counsel may have some questions.
Mr. Cruz? Yes, go ahead, sir. All right, cross-examination, Mr. Cruz.
Ms. Lycone, good morning. My name is Attorney Ahmad Cruz. I have the privilege and honor of representing Mr. Edrick Faust. We previously had opportunity to speak yesterday. Is that correct?
Correct.
Okay. And would you tell the jury, is it true that you would agree that you're from California? Is that right?
Yes.
Okay. And the state of Georgia brought you here from California to testify about the testing that you conducted in this case. Is that correct?
Correct.
Okay. And if you know, other laboratories in the United States conduct RSID saliva testing. Is that right?
Yes.
Okay. And even some laboratories in Georgia. Is that correct?
I don't know.
That's fair. Other labs also conduct the Lugol's iodine test. Is that correct?
Correct.
Now I want to ask you this. You've been doing this since 2022. Is that fair?
Yes.
But you have never been asked to come into court and testify to the Lugol's iodine test. Is that right?
Correct.
And I think we agree on this. So this is your first time being asked to testify on these presumptive tests.
Correct.
How about the RSID test?
Is this my first time?
Correct.
Yes.
Okay. So no other state has said, hey, can you come testify about these presumptive tests to a jury?
Correct.
And neither are confirmatory tests. I think, excuse me, there aren't any confirmatory tests for these two tests. Is that right?
Correct.
Now I want to ask you this. You were given some packages that involve swabs. Do you still have those up there with you?
I don't.
I'm going to give you a pair of gloves.
Okay.
Let the record reflect that I've given Ms. Lycone a pair of gloves. I've given her State's Exhibit 141. I am also going to give her State's Exhibit 142 and a pair of scissors. All right, Ms. Lycone, can you open the two packages that you have?
I am going to object to the relevance of having this witness open that package, especially in light of what happened yesterday.
Mr. Cruz?
Sure. The state introduced those items as exhibits. I believe we expressed on the court before that it's the items that's inside that is relevant. We just want to see the items that's inside, so I can ask her some questions about that.
I'm going to take a step outside the presence of the jury, and we are going to have a restroom break. So if you'll go into the jury room, this will be a restroom break. Mr. Cruz, I'll certainly give you one as well. Please don't discuss the case. If you'd like to do that first and come back, that'd be fine.
Thank you, Your Honor.
Go ahead, sir.
Court is on a short break. Don't go anywhere. The action will be right back on at Southern Sin. Subscribe to at Southern Sin and hit the bell for when we go live.
Thank you for subscribing to At Southern Sin. Keep our algorithm high by hitting the like button now and use hashtag Sinners in the chat to win a free membership.
You're watching At Southern Sin, your home for true crime. Court will begin shortly. Don't go anywhere.
Thank you for subscribing to At Southern Sin. Keep our algorithm high by hitting the like button now and use hashtag sinners in the chat to win a free membership.
Before we begin, now that we're outside the presence of the jury, anything further from the state about the objection?
No, it's just a relevance objection, Your Honor. I mean, Ms. Lacan testified that she received those items sealed and then, opened them to conduct the testing that she described. I apologize. I have a lifesaver in my mouth. I didn't know we were going back on the record so quickly. And I just can't see the relevance of actually having her open that. I don't see how that's going to be, make any material fact more or less likely for the jury's perspective. And then I also, again, in light of yesterday's incident with the slides, it seems like a bad idea. And so legally speaking, I would couch it in the form of a relevance objection.
All right, thank you. Thank you. Mr. Cruz.
Excellent. I think the state is precluded from arguing relevance because they introduced the items into evidence. As your Honorable Court is aware, I before have asked the state, before they introduced any of it, I believe I asked Mr. Yalamachili when he showed them to me to open the package. I believe I raised an objection with the Honorable Court. We don't know what's in the items, and I think it's even more relevant the fact that we had one incident where we opened envelopes and they were completely empty. So what's in the package is relevant in this case. I'm going to ask her, are those items she tested? And I'll go down that line of questioning once she's able to identify what's in the package. As of right now, the state is just presenting packages saying, hey, take it for what it is. That isn't authentication. We want to authenticate these items and then ask the witness questions about those items.
All right, thank you.
But I won't pass it to the jury solely.
Okay, well, let's talk about that moment. All right, hang on just a minute. Mr. Bill, is there anything else?
No, Your Honor.
Okay, thank you. Hang on just a minute. All right, thank you very much. All right, I'm going to overrule the objection and allow Mr. Cruz to ask this witness to open the package, but I'm not going to allow it to be sent to the jury. I think that incident yesterday is indicative of the danger of doing that. There are methods if the jury wants to look at evidence that is sensitive, particularly during deliberations, and we take it up in the courtroom, we deal with it in that manner. I'm not necessarily making a finding that this is actually relevant, but you are on cross-examination. I'll allow you to do that. All right, anything else? All right. Well, I did tell them we had a restroom break. Can you knock on the door and see if they're ready? Thank you. All right, very good. Be at ease until then, until we're ready. you. Now that we're back on the record, I do want to tell everyone in the audience, since we have a number of people in here, and it's gotten busier since we started, and I don't know who was here yesterday, if anybody. So I'm just going to remind everybody in the audience that with the exception of the media who have been provided a Rule 22 permission, with the exception of attorneys who are here in the courtroom, who are also here in the courthouse, if you'll just tell them to hang on just a second. Thank you. With the exception of attorneys who are here in the courthouse, perhaps watching, but also doing business here in the courthouse, with the exception, of course, of law enforcement who is here, who needs to be in other areas and need to be on their cell phone. With those, and the attorneys at the table, the exception of those persons, no one's allowed to use their cell phone while they're here in the courtroom. So if you have one, obviously make sure it's on silent, please. And please put it away. And thank you. The other issue that I want to bring up for counsel with regard to the ruling that we just made is I think it is probably best, and I'm going to make this part of the order, that only this witness handle the actual contents of the actual exhibit.
Yes, ma'am.
All right, thank you. You may bring the jury out.
I think so. The Edrick.
All right, you all may be seated. Thank you. Mr. Cruz?
Okay. Thank you, Your Honor. Can you open the 2 envelopes that were provided to you?
Yes.
Can you hold it up?
Yeah. Do you want me to do one at a time or?
Please.
Okay. So this is cuttings of item 2I.
And may I approach, Your Honor, just so I could get a better sight on it?
You may.
And then this is cuttings of item 2J.
Now, you'd agree that the items that you received were cuttings of swabs. Is that correct?
Correct.
Okay. Inside of the tubes that you have, do you recognize those swabs is what you tested?
Yes.
Do you know where those swabs came from?
No.
The only information that you had about the swabs were that they were oral swabs. Is that correct?
Correct.
At any time were you advised that the swabs were over? Well, let me ask this. What year did you test these swabs?
In 2024.
You remember what month in 2024?
I can see on the envelope, it was October of 2024. I tested them.
October 2024?
Yes.
Okay. Were you aware that these swabs were collected close to 23 years, well, past 20, close to 24 years prior?
At the time, no.
The items that you tested, you don't know when, or excuse me, you don't know when they were collected. Is that right?
Correct.
You don't know where they were collected from. Is that right?
Correct.
You don't know who those swabs belong to?
No.
Okay, so you weren't given any of that information?
No.
You simply received a package labeled oral swabs.
Correct.
Okay. And question for you, you have the swabs up there with you. Would you agree that I may say this wrong, but the swabbing material, the cotton, in some places is pretty much white. Is that fair to say?
Yes.
Did you know that those swabs that you tested had been considered oral swabs for close to 24 years?
I would object to the characterization in that question.
All right. Most specifically, what's your objection?
I would object to the use of the word considered oral swabs versus labeled oral swabs.
I'll allow it, but you may follow up if you choose to do so with any redirect. Go ahead.
Sorry, could you repeat the question?
Sure. Were you aware that the items that you received had been considered or labeled oral swabs for 24 years?
I was not aware of the past characterization of them.
Okay. So is it fair to say that as you sit here today, you don't know if the swabs that you tested are the same swabs that were collected?
Correct. I'm only aware of what we received at our laboratory.
That's fair. Course indulgence. My last question for you. You mentioned this is your first time talking about these tests. Are you aware of anyone else being asked to testify about the Lugol's iodine test in court?
Sustained.
Those are my questions. Thank you so much for your time.
Any redirect, Mr. Bolden?
No, Your Honor.
May this witness be excused.
Please.
Any objection from the defense?
No, ma'am.
You are free to go. And you may call your next witness.
Thank you, Judge. I think that myself and Mr. Cruz need to review the exhibits that are going to be used with the next witness.
Okay. How much time do you need to do that?
I mean, a couple of minutes, Your Honor.
All right, go ahead and just do that. All right.
If it's okay with the court, just to allow us to speak a little more freely about it. All right, Mr. Cruz and I step into the hallway.
Yes, that's probably best. Thank you. We'll be at ease, everyone. If anyone needs to use the restroom right now, certainly you can do that, but we just did take a break, so we're going to stay seated for just a moment.
Your Honor, I think we're going to have to address something with the court.
All right. Ladies and gentlemen, I am going to ask you to go into the jury room. Please don't discuss the case. We'll be with you shortly. Thank you. Y'all may be seated. Thank you. All right, go ahead.
Thank you, Your Honor. This goes back to some pretrial rulings by the court based on the court's ruling and the defense's proffer that pursuant to the state's sodomy motion that Mr. Melton would be the only alternative suspect raised by the defense. The reports, beginning with State's Exhibit 136, makes reference to an individual as a suspect who is neither Mr. Faust or Mr. Melton, and so the state would seek to redact that pursuant to the court's order. It's not relevant, and under 403 would be confusing to the jury. As it relates to State's 137, same thing. There's an individual listed as a suspect who is not one of the noticed individuals from the court's ruling on sodomy motion. 403, again, it would be excluded. I don't know that the state is going to get into, 138, yes, again, same individual's name needs to be redacted in the suspect line. As it relates to 139 and 140, Judge, there are a number of individuals' names on here that kind of fall into that same category I was speaking of previously. They are not Mr. Melton or Mr. Faust, and thus their names need to be redacted pursuant to the court's ruling because it would be confusing the jury under 403. So that would be the state's position, and I understand after discussing that with Mr. Faust, the defense is not in agreement as to that.
All right, thank you. Mr. Cruz, anything, sir?
Yes, ma'am.
All right.
A big portion of this case is the police's investigation and the way that investigation was conducted. Our position would be that other suspects that were looked at should be considered by the jury as opposed to making this case solely about Mr. Melton and Mr. Faust. As I stated in my opening, Your Honor, the jury's job isn't to determine whether or not Mr. Melton committed this crime. The jury's determination is to determine whether or not the state has presented enough evidence that Mr. Faust is the person that committed this crime. I do believe that in regards to the 401 objection, it is relevant. Law enforcement looked at other individuals. I believe in the reports, since I'm making the argument, they look at other individuals, but they don't have their, in this particular case, hair fibers, because it's hair, their hair, because these are hair tests. They have these individuals listed as the suspect, but they don't have any of their biological material. So it is relevant. I don't think it'll confuse the jury because, again, as I explained to the court, you have this person listed as a suspect, but in the report, you don't have this individual's biological materials. So I would ask the Honorable Court to allow or restrict the state from restricting that individual's name off of the testing form, Your Honor.
Thank you. Anything further? Mr. Yalman-Chile, it's your motion.
I think the law stands for a contrary proposition, which I argued to the court.
All right, thank you. So, Mr. Cruz, your argument is in direct violation and contradiction to all of the orders that have been entered in this case. And I've said many times, and I will say it again today, that the defense had the responsibility, if it chose to enumerate other possible suspects, that not only did they have to, by law, provide the proper notice to the state that they were going to seek to introduce evidence as to other persons, But also a hearing needed to be scheduled pursuant to that notice. That notice is in the form of a motion. And we've talked about this many times. That has not been done by the defense, with the exception of Mr. Melton. And we had that hearing. And that evidence that both parties sought to admit with regard to Mr. Melton was agreed by the parties and accepted by the court that would be admissible. I mean, not all of it, but just in general. But any other mention of any other suspects or things of that nature were prohibited based on the rulings by this court in several hearing days that we have had. And so I say that again to say that because of those rulings and because of the legal procedure that was not enlisted by the defense to get the proper permission to be able to talk about other possible suspects, it is prohibited. It is also not relevant based on the prior rulings. I agree with the state that under 403, confusion of the issues would be paramount in this moment. And so I'm going to order the state to redact those particular exhibits. I think they're 136, 137, 138, 139, and 140. Am I right about that?
Yes, Your Honor.
All right. I'm going to order the state to redact those exhibits, as we previously discussed, with regard to those rulings. I mean, I think that's, we've kind of gone over this.
May I respond, Your Honor? May I
You
be
may.
heard? And I believe I may have explained it wrong. I am not saying that we want to say that this third person did anything. We're saying that it's relevant because it goes to law enforcement's investigation. And please forgive me for I probably didn't state that the first time, but they're saying, hey, this person was a suspect. However, the test is biological testing. The relevance for us is we're showing law enforcement said this person is a suspect, not because we're saying they committed the crime. We're saying, look at the work they did. Person A is a suspect, but they don't have any of person A's biological material. And please forgive me if I misstated that the first time.
Well, I did actually understand this part of your argument.
Understood.
I did. And with regard to the comments you're making about the police work and how they conducted it, I'm not making a finding about that issue. But my ruling stands.
Yes, ma'am.
Because the defense has failed to provide the proper motion and notice that the law requires in order for the court to then make a determination as to even whether that evidence should be admitted. And so because of that, regardless of the reason that the defense or any party wants to introduce that evidence, it is prohibited.
Yes, ma'am.
All right, thank you.
Thank you.
How much time do you need, Mr. Yelman-Chili?
Just a couple of minutes.
All right.
And then I'll hand it to Mr. Cruz
Okay.
to make sure he has no objection as to form.
All right.
I understand he objects in general.
Okay.
And then one request I would make of the court is, we can redact it for today with a Sharpie. We also have the ability, though, to black it out digitally and then reprint the report with that blackout. And so at the appropriate time, I'd ask to, submit an alternative redacted version of the exact same report. Obviously, it's just a digital file at that time.
All right. I guess my question for the redaction process is, do you need to make a copy of that exhibit and then do it, or?
I think it's fine.
All right, I'll just leave that to you. We
Thank
just
you.
need to make the record clear. All right,
Yes.
we will take a 10-minute recess. I'll be back on the bench in 10 minutes. Thank you. All right, we are back on the record. Has the state finished the redaction?
We have, Your Honor, there may be a separate issue that we need to address with the court, though.
Okay.
And I haven't had a chance to talk with Mr. Cruz about it. It just came to our attention. But can we do that initially off the record or in chambers to discuss how the court wants to handle it?
Yes. We can do it in chambers if you want to do that. Let me see y'all dimension just for a minute. It can be on the record, it's fine. So, I'm happy to do
Okay, thank you.
it.
Oh, no, do you want to tell the judge?
Court is on a short break. Don't go anywhere. The action will be right back on at Southern Sin.
We are back on the record. Before we get started, is there a Jessica Berryman present in the courtroom? I hear no response. All right, counsel for the state, are you ready for the jury to come in?
We are, Judge.
Ms. Cruz? All right, thank you. You may bring the jury in. Be seated. Mr. Yalamanchili?
Thank you, Your Honor. State calls Larry Peterson.
Could you get Larry Peterson? Thank you.
Sir, if you would raise your right hand, do you swear or affirm testimony you will give to the jury today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you would, please state and spell your name for the record.
Larry Keith Peterson, LaryKeithPeterson.
And sir, are you currently employed in full-time capacity?
I am not. I'm retired.
All right. And when's the last time that you worked full-time?
I was retired from the GBI Crime Laboratory in 2008. So I was employed there from 1978 to 2008. In 2008, I was employed by the U.S. Army Criminal Investigations Laboratory until I retired from there in 2017.
Okay. And going back to before your employment, what type of educational background do you have?
Yes, I have a Bachelor of Science in Forensic Science from the University of Central Florida.
And what was your first job after college?
Was employment at the GBI Crime Laboratory.
Okay. And so between the GBI and the United States Army, how long did you work in forensic sciences?
Probably almost 40 years.
And as it relates to, we talked about your educational background prior to starting work at the GBI. What type of training did you receive when you went to the GBI?
Right. So scientists at the GBI trained me in various aspects of trace evidence analysis. During my employment, there was also attendance to seminars and classes on the evaluation of trace evidence, including professional organizations and, personal relationships with other scientists.
Do you have any professional affiliations from your time working in forensic sciences?
Yes, I was and currently in emeritus status with the American Board of Criminalistics. Also American status with the American Society of Trace Evidence Examiners. I'm a retired member of the American Academy of Forensic Scientists and retired and past president of the Southern Association of Forensic Scientists.
And as it relates to the Southern Association of Forensic Scientists, did you ever serve as president of that organization?
Yes, I did.
All right. Have you ever had any publications regarding forensic sciences?
Yes, I've published several articles on trace analysis.
And have you ever been recognized for your work in forensic sciences with any types of awards?
Yes.
Your last title at the GBI or job responsibilities, what was that?
The title was a microanalyst, generally a person who's responsible for evaluating what's generally considered microscopic or very small amounts of material.
Okay. Did you have any leadership roles as it related to your time in the trace evidence section?
For approximately the last 9 years, I was deployed with the GBI. I was the trace evidence not supervisor, but I was supervising the competency as technical leader of the section.
And you said supervising the competency as technical leader of the section. Can you elaborate a little bit on what that means?
Generally, it's the person who is responsible for reviewing and generating revised protocols and procedures, and also oversees proficiency testing.
Okay. And have you ever testified as an expert in any fields?
Yes, I've testified on over 400 trials in various aspects of trace evidence.
Okay. And as it relates to various aspects of trace evidence, have you testified as an expert in the field of human hair analysis?
Yes.
Okay. And have you testified in the states, in the courts of the state of Georgia?
Yes, state courts as well as federal and military as well.
And Your Honor, at this time, I would move to tender Mr. Peterson as an expert in human hair analysis.
All right, any objection from the defense?
No, ma'am.
This witness is qualified or tendered as an expert in human hair analysis. You may proceed.
Thank you, Judge. Mr. Peterson, next, I would like to talk to you a little bit about human hair analysis. And I would like to start with the science behind human hair analysis. Do human hairs contain any unique or variable characteristics?
Right. So the science of comparing hair is that a recognition that hair contains several basic parts. So there's a cuticle outer structure of a hair. There is a basic protein, the main portion of the hair called the cortex. Some hairs contain what's called a medullary structure, a medulla, which is kind of an air-filled tubular structure that can appear down in the center of some people's hair. So based on, and the cortex of the hair contains the pigment granules, which gives the hair its color. So there's an evaluation microscopically of all of these features, both from a gross microscopic or a low power magnification view, as well as a detailed comparative, detailed microscopic comparison with a question and a known hair, and attempt to determine if there's an association between those two samples.
And so as it relates to the variable characteristics that hairs can have, are there certain characteristics that have a lower rate of occurrence and will be more unique as opposed to other characteristics that have a higher rate of occurrence and less unique?
Right. Some hairs possess fewer characteristics than others just based on the amount of features that are available in the hair. For example, a very fine diameter blonde hair would have fewer characteristics to observe than a larger, more heavily pigmented hair.
Okay. And as it relates to hairs, an individual strand of hair, is that uniform from one side of the hair to the other side of the hair?
No. In the examination process, it's understood that the root end, or what we call the proximal end of the hair, would have different characteristics as you progress along the length of the hair towards the distal or upper end. It's just a natural progression over time, how hair changes as it grows.
And now I want to shift with you to the process of conducting a hair analysis. Is there a scientifically accepted process for conducting that analysis?
Right. So as I described, so in the process of procedure, you would start with the mounting or the collection of the hair, whether it was submitted as a collected hair or it could have been submitted as an item of clothing or something else. And then hairs would be recovered in the laboratory. However that process happened, the hairs would be mounted on a glass microscope slide in a mounting media to allow for its closer examination, which would begin with the stereo or low power magnification around 10 to 40 magnification. In that classification process, we can look at the overall length and color, the shape of the hair, give some idea of maybe some racial origin information, certainly body area origin as well, and can be the first step in the association or the elimination of a question hair from a known hair sample. So a question hair would be one of unknown origin. It's a hair recovered from a crime scene or something of unknown origin. And we would have known hairs, a collection of hairs that represent the known hair of a particular individual. That range of knowns would be fairly tight to one another, but even hairs collected from a single individual is not going to be identical to one another, but they're going to be very, very close in characteristics compared to known samples from other individuals. And so in the comparison process, it is if it's not eliminated at the stereo microscope, it's transferred to a comparison microscope, which is where light is transmitted through the hair samples on two microscopes. The two microscopes are hooked together with an optic bridge so that you can view the internal characteristics side by side. And at the end of that process, if following the examination of the hair from the entire length of the hair, if that question hair falls within the range of the known sample, we can conclude that that hair is associated with or could have originated from that person. If it fails in that examination at any stage, it would be eliminated as potentially originating from that person.
As it relates to this particular case in the murder of Miss Tara Baker, were you asked to conduct certain hair analyses as part of your work at the GBI in this case?
Yes, in 2001, I was employed by the GBI laboratory and performed examinations on the Tara Baker case.
Okay. And so what I'm going to do at this time, Your Honor, I'll show Mr. Cruz what I'm going to hand to the witness, but I'm going to hand the witness some exhibits that have already been admitted into evidence. All right, Mr. Peterson, I'm going to hand you this little box lid that's full of some slides as well as some envelopes. Starting with the envelopes, do you mind going through those and taking a look at them?
Yes, sir.
All right. And so do you recognize those envelopes?
Yeah, these are samples submitted to the laboratory for analysis. They all contained a unique case number for the laboratory, 2001-1002454. And that was the case number associated to the Tara Baker case.
And what are the exhibit numbers on those envelopes?
We have defense exhibit, I believe that's 17, 16, and 11.
Okay. And let me ask you this. We talked about the process that the GBI lab goes through when hair analysis is being conducted. Is it the typical process of the GBI crime lab after a hair that's being analyzed has been mounted to remove it from its mounting, put it back in the envelope and send it back to the law enforcement agency? Or is it the typical practice for it to remain on the mounting that it was placed on for analysis purposes?
Right. No, it would be left on the slide that it was removed to, and that would become its permanent status at that point.
Okay. As to those envelopes that I've handed you, are they sealed or are they open?
They appear that they have been cut open from one end.
Okay. Do you see anything on those envelopes that would help you recognize whether or not you had ever interacted with those envelopes?
Well, yes, each envelope, in addition to the laboratory number, has my initials on the envelopes.
And what I'd like to do is retrieve those from you now. And Judge, I'd ask to publish them on the Elmo.
All right, ready?
And I'm going to start with State's Exhibit, or I'm sorry, Defense Exhibit 11. And I just want to point to one part of this. What is that my finger is next to there?
That's the initials that I use on evidence.
Okay. And Defense Exhibit 16. I'm going to flip it around the other way. Sorry. What's that I'm pointing to?
Also my initials.
And lastly, Defense Exhibit 17. And right there, what am I pointing to there?
Yes, my initials.
The hairs you received I think you already indicated those would be mounted. When they are mounted on a slide and then maintained in that medium, I want you to review now the slides that are in front of you and let me know when you've had a chance to look through all of those.
Yes, I believe these are the slides that I had earlier recognized, that these are boxes containing the prepared slides with mounted hairs.
And I'm going to retrieve one other thing, and then I am going to have some questions for you about that. I apologize. Should have retrieved these before I got you on the witness stand. I'm going to show Mr. Cruz what's already been admitted into evidence as State's Exhibits 108, 109, 110, and 111. Good. And Mr. Peterson, I'm going to hand you those items now. And I'm going to ask you the same question that I asked you about the 3 envelopes. Do you recognize those bags, is what I'll refer to them as?
Yes, sir.
And how are you able to recognize them?
Well, each of these exhibits contains the laboratory unique case number 2001-1002454, as well as my initials on each item.
Okay. And did those appear to be in substantially the same condition as when you received them from Athens-Clarke County Police Department?
Yes, there may be some additional seals, but the container itself is the same.
Okay. All right. Now, going forward to the slides in that box in front of you, you had a chance to review those. Do you mind telling the jury what exhibit numbers you are looking at?
Well, I may not say these in order, but I will just go down through the list of the boxes. So I have State's Exhibit 124, 122, 125, 114, 117, 118, 121, 123, 119, 120, 116, 115, as well as Defense Exhibit 31.
All right. Thank you, sir. And I think, did you previously testify that these include the slides that you conducted your analysis on?
Yes.
Okay. Did you generate any reports in association with the analyses that you conducted?
Yes. I produced several reports.
I'm going to hand you first what I've marked as State's Exhibit 136 after I show it to Defense Counsel. And I'll actually go ahead and hand you State's Exhibit 137 as well. And Mr. Peterson, looking at State's Exhibit 136 first, do you recognize what that is?
Yes, so this is an official report issued by the laboratory that shows the results of my examinations.
And what date is that report from?
February 2nd of 2001.
And does it appear to be a true and accurate copy of your report associated with your analysis on that date?
Yes.
And Judge, I move to tender 136 at this time.
Any objection? It is admitted.
All right. So looking at 136, does it have certain numbers associated with items that you received?
That's correct. So when evidence is submitted to the laboratory, it's given an exhibit number in addition to a case number.
Okay. And so those numbers that we're about to refer to, those would be, by your terminology, an exhibit number. Is that correct?
Correct.
Okay. Was there an exhibit number 2?
Exhibit 2 is a sexual assault kit, identified as that from Tara Baker.
And as it relates, was there an exhibit number 8?
Yes, exhibit 8 is identified as question hair recovered from the buttocks of the victim, Tara Baker.
And was there an exhibit number 9?
Number 9 was an item identified as question hair from the torso of the victim, Tara Baker.
And then where did exhibit number 10 come from?
10 is identified as question hair recovered from the left hand of Tara Baker.
It also, as part of this submission for your analysis, were you given known hair samples from any individuals?
Yes, that shows 5 known hair samples that were submitted on that same day.
And starting with exhibit 21, whose hair sample was that?
Known head hair of Chris Melton.
And exhibit number 22?
Known head hair of Christopher Hall.
And exhibit number 23?
Known hair of Jeff Hall.
And exhibit number 24?
Hair sample of Ashley Peavy.
And then exhibit number 25?
The hair sample of Valerie Lang.
Okay. And as part of that sexual assault sexual assault evidence collection kit of Miss Baker, would there have been known head hairs as part of that kit?
Yes.
Okay. So now we got the known head hairs of Tara Baker, Chris Melton, Christopher Hall, Jeff Hall, Ashley Peavy, and Valerie Lang. Is that correct?
That's correct.
Okay. And then as far as hairs for which you are being asked to do a comparison analysis to see if there are any associations, you have a package identified as containing hair collected from the buttocks of the victim. You have package containing hair collected from the torso of the victim. And then you have a package containing the hair from the left hand of the victim. Is that correct?
That's correct.
Okay. I want to start with the comparison between the known samples in exhibits 2 and 21 through 25 against the hair collected in exhibit 8 from the buttocks of Miss Baker. Did you perform an analysis related to that?
I did.
Okay. And what, if any, opinion do you have based upon your findings as it relates to Exhibit 8?
Exhibit 8 revealed that there was one head hair microscopically consistent with the known hair of the victim, Tara Baker. There were 2 hairs inconsistent with the known hair of Ms. Tara Baker. And subsequent comparisons show that they were consistent with the known hair of Ashley Peavy.
And so let's talk about consistent with the known hairs of an individual. What does that mean?
It means basically that they had a correspondence in their microscopic characteristics that in comparing the question hair to the known hair, they possessed sufficient similar characteristics to they could be included as a possible donor of the hair, that either would be from that person or another person possessing hair with the same characteristics.
Okay. And so as it relates then to Exhibit 8, and please correct me if I misstate anything about your findings, of the 3 hairs that were of a quality that could be analyzed, 1 was consistent with Miss Baker and 2 were consistent with Miss Peavy. Is that correct?
That is correct.
Okay. I want to go forward to Exhibit 9, which is collected from the torso of the victim. As it relates to your analysis on Exhibit 9, what opinion were you able to develop based on your analysis?
Exhibit 9 indicates that there were numerous head hairs consistent with the known hair of Tara Baker, the victim. 1 head hair inconsistent with the known head hair of the victim. And then further microscopic examination of that particular hair against the known hair of Valerie Lang showed them to be consistent.
So the hairs that were analyzed there were some that were consistent with Miss Baker, the victim, and then the one that was not consistent with Miss Baker was consistent with Miss Lang. Is that correct?
That is correct.
Okay. And so as it relates to the hairs that were found to be consistent with Miss Hall and Miss Lang that were recovered from Miss Baker's body, those were also compared against Mr. Melton, weren't they?
Yes.
Okay. And what was your finding regarding those hairs as it related to Mr. Melton?
Well, the hair was eliminated as potentially originating from him.
Okay. So as it relates to items 8 and 9, those hairs could not have come from Mr. Melton. Is that right?
That's correct.
Okay. And now I want to get to Exhibit 10, which is the hair from the left hand of Miss Baker. Based on your analysis of that hair, what opinion did you form regarding that hair?
The hairs identified from the left hand of Tara Baker, there were several head hairs and one pubic hair, all of which had the similar characteristics as Miss Baker's own hair.
So they were consistent with Miss Baker's hair, is that correct?
Correct.
And so that head hair, or I'm sorry, not head hair, that hair that was recovered from Miss Baker's left hand, was it compared with Mr. Melton as well?
Well, the head hair would have, yes.
Yes. And so that head hair that was compared with Mr. Melton, what opinion did you form as to whether or not that head hair could have come from Mr. Melton?
He was eliminated.
Okay. And what does eliminated mean?
Did not have corresponding microscopic characteristics.
As it relates, sir, to Exhibit 137, states 137, do you mind telling me what that is?
Again, this is an official report which I produced under the same case number 2001-1002454, the case number for Tara Baker, issued on February 27th of 2001.
And is that appear to be a fair and accurate copy of the report that you generated based on your analysis on that date?
It is.
Judge, I moved to tender states 137 at this time.
Any objection? It is admitted.
And as it relates to states Exhibit 137, Mr. Peterson, it makes reference to Exhibit 2 again. Is that correct?
It does, yes.
Okay. And Exhibit 2 is the sealed sexual assault evidence collection kit of Miss Baker. Is that correct?
That's correct.
Okay. And in there, it has listed in Exhibit 12. What is that?
Exhibit 12 is identified as there's a power transformer.
Okay. And did you have an opportunity to process that item for any kind of trace evidence?
Yes, hairs were recovered from that item.
All right. And so this power transformer, the hair that you analyzed that was recovered from that, what, if any, opinion did you form?
There were several hairs that were unsuitable for comparison. They did not possess enough characteristics to produce a meaningful comparison. In addition, there was one head hair which was suitable for comparison. And additional examination comparison of that hair showed it to be consistent with the known hair of Chris Melton.
Okay. And so that's a separate thing than anything that was found on Miss Baker's body, though. Is that correct?
I believe so, yes.
All right. I want to go back now to exhibit number 10 in the hair that was in Miss Baker's hand that was consistent with her and eliminated Chris Melton. Have you had other occasions where you have examined hair that's been found in the hands of a homicide victim?
Yes, I have examined a number of cases, a large number of cases where hairs were recovered from the victim's hands. And the vast majority of time, the hairs were always consistent with the victim's own hair.
Okay. So this finding wasn't an unusual finding then. Is that fair to say?
It was not.
Okay. If I could have just a moment, Your Honor. Mr. Peterson, thank you very much. I don't have any other questions for you, sir. I'm sure Mr. Cruz will have some.
Mr. Cruz, cross-examination.
Mr. Peterson, thank you so much for your time. The state asked you about the power transformer and the hair found on the power transformer. Do you remember that?
The notes reflect that it happened. This case happened a long time ago.
Correct. My question is, do you recall the state asking you about a power transformer and hair found on the power transformer?
Well, I mean, we just discussed it. Yeah,
Sure.
yes.
Okay, excellent. You don't know where that power transformer was located in relation to Ms. Baker's body, do you?
No, I do not.
I'd like to go over some of the hairs and the examinations you conducted. Is that okay?
Okay.
And I'd like to establish something first. So would you agree that Caucasian hair is different from African-American hair?
I would agree.
Okay. And would you agree that based on your profession and expertise, Caucasian hair is easily distinguishable from African-American hair? Is that fair?
The vast majority of times, yes.
You examined a hair from the buttocks of Miss Baker. Do you recall discussing that?
Yes,
That hair was not consistent with African-American hair. Is that correct?
that's correct.
You examined the hair from the torso of Miss Baker. Is that correct?
That's correct.
That hair was also not consistent with African-American hair. Is that correct?
That is correct.
You examined hair from Miss Baker's left hand as well. Is that correct?
That's correct.
And you would agree that hair was also not consistent with African-American hair. Is that correct?
I agree.
We discussed the power transformer, but you examined hair from the power transformer. Is that correct?
Correct.
Okay, and the hair on the power transformer was also not consistent with African-American hair. Is that right?
That's correct.
And I believe you testified that the hair found on the power transformer was consistent with Chris Melton's head hair. Is that right?
That's correct.
You even examined the hair found on Miss Baker's wallet. Do you recall that?
There was a hair identified as from the victim's purse, I believe.
From her purse?
It's identified as a purse.
Okay. And that was a pubic hair. Is that right?
No, I believe that was a head hair.
Your Honor, I would move to introduce Mr. Peterson's. Course indulgence.
And Your Honor, I would have an objection. I don't believe that the items that Mr. Cruz is asking this witness about have been tendered into evidence by either party. So I think that would be required prior to questioning the witness about the items.
Go ahead, sir. Yes.
Well, I disagree with that, Your Honor. I asked him a question about testing that he's conducted. The testing is within this witness's personal knowledge. He has gave a statement that is inconsistent with the report that he's written, and I'm introducing this report as a prior inconsistent statement.
All right. Let me see counsel at the bench for a minute, please. Thank you. Thank you. All right, ladies and gentlemen, I'm going to give you all your lunch break now. And so it has arrived. So if you'll go into the jury room and we'll present it to you, we're going to be back on the record in 40 minutes. And please don't discuss the case. We'll see you at 1 o'clock. Thank you. All right, court is in recess till 1 o'clock. Thank you.
I mean, that's fine.
Court is on a short break. Don't go anywhere. The action will be right back on at Southern Sin. You're watching at Southern Sin, your home for true crime. Court will begin shortly. Don't go anywhere.
You'll have a seat, Mr. Peterson. Thank you. And we'll go back on the record. All right. So there was some discussion at the bench about Mr. Cruz wanting to use a document to examine this witness under 24-6-613. The state asked, pursuant to that statute, certainly, to get a copy of what you were using. And then the state made an argument pursuant to 603. To 403. And so because of the state's argument about 403, the balancing test, I wanted to go through this moment outside the presence of the jury before I make a ruling. And so, Mr. Cruz, I'm going to let you examine this witness with that moment. And the law requires that you allow the witness to, I'll just use this language of the statute. The witness is first afforded an opportunity to explain or deny the prior inconsistent statement, and the opposite party is afforded an opportunity to interrogate the witness on the prior inconsistent statement or the interest of justice otherwise requires. So before I get to that portion of the statute, I want to hear what we're talking about because the state has made a 403 objection. So you may proceed, Mr. Cruz. With the question you were going to ask him. He answered a question and you wanted to attempt to impeach him with a prior inconsistent statement. The state objected based on 403 grounds, and so that's why I'm conducting this hearing outside the presence of the jury.
Excellent. So just to let you know the process that was taking place when the objection was lodged, I was about to mark this as defense exhibit, I believe, 32.
You asked me if I have it, defense exhibit 32?
Oh, no, sir. I was asking.
Not yet.
I'm sorry.
Not yet.
Okay. So I was going to mark this
Okay.
as defense exhibit
All right.
32.
Okay.
And my next question to him after I mark this as defense exhibit 32 was going to be in your March 19th, 2001.
Well, actually, before we even get to that, Mr. Cruz, you may not need to get to that moment. Let me ask you this question. Let me ask counsel. Now that you're going to mark it as an exhibit, it kind of takes a different turn.
That's where the objection came.
Okay. So, well, it did because you weren't tendering it, and you don't necessarily have to when you're dealing with a prior inconsistent statement.
I actually was going to admit the prior inconsistent statement.
Okay.
But I typically mark it for purposes of the record.
Okay, well, that's fine. Well, let me ask this question of the state first. Based on that he is going to offer it into evidence, do you have any objection? Do you have any objection to that? I mean, based on the conversation counsel had with the court at the bench, the reason I'm doing this outside the presence of the jury is because of the 403 argument. So is there any objection to the tendering of that document? Is there going to be?
I'm sorry, Judge.
Is there going to be any objection to the tendering of that document?
I think that there would be, as it relates to examination regarding a hair found in a wallet. And the reason is, Judge, and I would, if the court allows me under 24-1-104, I think this would be a matter of a preliminary question. And I can state in my place that pursuant to documents that are in discovery and produced to Mr. Cruz, this item actually didn't come into, the item was not believed to contain any hair at the time of the initial processing of the crime scene. It was returned to the Baker family, who then over 2 weeks later, on February 8th of 2001, brought the wallet back to Athens-Clarke County Police Department and relinquished custody to the Athens-Clarke County Police Department. And then subsequently, in a transcript of an interview between ACCPD and the Baker family in May, Miss Baker's father, Mr. Lindsay Baker, stepfather, but the person she considered to be her father, Mr. Lindsay Baker, indicated to police that we found a hair in that wallet. What have y'all done with it? And so I imagine what Mr. Cruz is going to question the witness about is whether or not that hair was tested. And so I guess our objection under 403, or it would, our objection pursuant to 24-1-104 is there's been a lot of discussion about chain of custody as it relates. Now, in this particular case, circumstance, I think there is a legitimate concern about chain of custody in the manner in which it came into the possession of law enforcement and GBI, which is why additional testing was not done. If testing had been done, it still probably wouldn't be admissible in a legal proceeding due to the fact that it came from a wallet that had left the crime scene and been in the possession of other parties for fairly extended period of time. We're not talking about an hour or something like that. So.
Okay. All right. Thank you. Mr. Cruz, do you want to respond to that? And then I'll let you ask the question. I may have some questions for you. Do you want to respond to that?
I just want to make sure I understand the objection was to 403, but also chain of custody. Am I understanding that correctly?
Well, I'm not going to put words in Mr. Yellman-Shilley's mouth. I can tell you what the court thinks it is, but go ahead.
Foundation for admissibility of the evidence that he is questioning the witness about. I think if we are going to talk about evidence, it needs to be present and tendered in the courtroom. Now, it could be that Mr. Cruz goes through the process of tendering that evidence in some manner. It just hasn't been done yet. So, I mean, I guess my objection's on a couple of different grounds.
All right.
Yeah.
Go ahead.
So I understand foundation is a ground, chain of custody is a ground, and 403 is a ground. If I could ask clarification from the Honorable Court or Mr. Yalamachili, as far as 403, what particular ground do I need to address?
You can ask the state.
Well, Your Honor, when we were at the bench, I think my original objection was actually to the predicate requirements of a prior inconsistent statement not having been met, because I think Mr. Peterson testified that he believed that it had come from a purse, and Mr. Cruz had indicated it had come from a wallet, and we stated at the bench, so it was our belief and our understanding of the evidence, it actually came from a wallet that was inside of a purse, so it wasn't necessarily something inconsistent with Mr. Peterson's testimony.
All right, so in regards to the foundation of a prior inconsistent statement, Mr. Peterson, I asked him, was it a pubic hair? He said it was a head hair. I asked him, was it on a wallet? He said it was in a purse. It's semantics, but my particular question asked about a wallet. His report references a wallet. It's not reference a purse. So the foundation has been laid for a prior inconsistent statement. He was confronted with the statement. Well, was about to mark the exhibit to confront him with the statement before the objection came about. But once I've given him an opportunity to, or once I've confronted him with that statement, if he says, no, it's still a head hair, or no, it was in a purse, at that time, I would tender this into evidence as impeachment material. In regards to the chain of custody, this isn't a chain of custody issue. Chain of custody applies to fungible evidence, not to documents. So chain of custody would not apply in this situation. In regards to the state's argument, as far as I need to tender the hair in order to impeach Dr. Peterson, in regards to the hair, there is no case, no law that exists that would support that proposition anywhere, probably in the United States. And lastly, in regards to 403, Your Honor, I still wasn't 100% clear on the exact ground of 403. So I would ask for the just look the specific grounds for 403.
Confusion of the issues and misleading the jury.
Okay. In regards to confusion of the issues in this case are whether or not Mr. Faust committed this crime. This evidence is evidence either in support of Mr. Faust committing the crime or evidence that goes against Mr. Faust committing the crime. The anticipated testimony from Mr. Peterson's report is that the hair that was on the wallet was a pubic hair, and it was of Caucasian origin, or the way I asked the question, it was not a African-American hair. I had no intentions to ask about testing the hair. I now do, but it's relevant. It won't confuse the issue because it goes directly in line with our theory that Mr. Faust was never in Ms. Baker's home. And this testimony supports that materially, Your Honor.
Mr. Cruz, let me ask you this question. Well, first, I'm going to let you ask him about a prior inconsistent statement and give him the chance to respond. And then I want to talk to counsel about something else.
Sure.
So you may go, because I don't agree that you've established that you have the right to present evidence about a prior inconsistent statement yet. So if you believe that's going to be the case, I'm going to let you try that.
Sure. May I mark the exhibit, Your Honor?
You can for this particular purpose, but we're having a hearing outside the presence of the jury.
Sure.
So just go ahead and ask him the questions you were going to.
Yes, ma'am. Thank you for your patience, Mr. Peterson. You obviously know where I'm going with this line of questioning, but you examined the hair found on Ms. Baker's wallet. Is that correct?
Yes, I had earlier said purse, just from my recollection, but by looking at the report, it does reflect hair from a wallet.
Okay. And would you agree that it's also a pubic hair?
No.
Okay. Mr. Peterson, in your report dated March 19th, 2001, did you state, of course, indulgence, I'm mistaken. You are correct. You are correct. Okay.
All right.
So we are clear on the wallet portion, and I was incorrect as far as the pubic hair. Please forgive me.
All right, thank you. So let me just respond then. well, before I respond, unless Mr. Yalamanchili, since it's your motion, do you have anything else you want to say about your argument about this information under 403?
No, Judge.
Okay. Mr. Cruz, do you want to respond to their argument about this evidence being violative of 403?
The proffer that I gave to the number court, I would stand by that.
Okay. All right. Thank you. So both parties have given a proffer about what this line of questioning is about. And I will say this, I agree with the state that this is violative of 403.
Yes, ma'am.
Because of the proffer that the state has made about the circumstances surrounding the testing of this purse, wallet, several weeks later, under the circumstances that they have described, is a moment, I would say, of profound confusion, possibilities for the jury. And so I'm going to grant the state's motion with regard to the concern about 403, and I'm going to instruct you not to go into that area of questioning with regard to the testing of this purse, wallet, this line of questioning. I'm going to instruct you not to go down that line of questioning.
But don't touch on the wallet to make sure.
That's correct.
Yes, ma'am.
All right, thank you. All right, I'm going to bring the jury in because I want everybody to be mindful. It is 1:20 and we are supposed to be ending at 2:30 today. As best we can, there's a juror that's going out of town. This may be our last witness, but I just want everybody to remember we're running behind. It's 1:20. So, all right, anything else? You ready for the jury to come back in this?
Ma'am.
All right, state ready?
Yes, Judge.
All right, if you'll bring the jury in. Thank you. You all may be seated. Mr. Cruz, your witness.
Thank you. Mr. Peterson, you would agree that there was pubic hair found in Ms. Baker's left hand?
Correct.
And that pubic hair was tested against the known sample of Mr. Melton's head hair. Is that correct?
No, that would only be compared against pubic hair.
So it's compared against Mr. Melton's pubic hair?
Yes. I believe that's correct.
All right, in your report, did you write microscopical examination and comparison of the question hair removed from items? I want to ask you this before I even answer that sentence. Item 10, we can agree, is the hair from Ms. Baker's left hand.
That's correct.
Okay. And in your report, you wrote microscopical examination and comparison of the question hair removed from item 10 with the known head hair of item 21, 22, and 23 reveals they have dissimilar microscopic characteristics and therefore could not have originated from the same source. Is that fair?
Yes.
Okay. And item 21 is listed as the head hair of Chris Melton. Is that correct?
Correct.
Okay. And I believe on director testimony was that hairs that grow in different areas have different characteristics. Is that correct?
Yes.
Okay. Can you show me the report where you tested item number 10 against Chris Melton's pubic hair?
Don't believe that's in the February 2nd report. I think that's in a subsequent report.
Sure. Can you show me?
I wish you would show me.
Sure. And was seeing all of your reports refresh your recollection?
Well, I have two reports, State's Exhibits 136 and 137.
Well, Mr. Peterson, you just asked me you wish that I would show you. I'm willing to show you. Would reviewing your reports refresh your recollection?
Yes.
Okay. I am going to show you your report, or let the record reflect that I'm showing you your report from March 19th, 2001, May 16th, 2001, October 11th, 2001, February 2nd, 2001, February 27th, 2001, and that's two separate reports, and March 19th, 2001. If you'll take a look at these documents to refresh your recollection and let us know once your recollection is refreshed. May I approach? And just so there isn't any confusion, to make the record clear, I am asking about the pubic hair found in her left hand being tested against Mr. Melton's pubic hair.
Well, if that hair from the hand, which was eliminated microscopically at the victim's own hair, if there had been another pubic hair sample submitted, then it would have been identified as also being consistent.
The answer to my question, my question is, was the pubic hair found in Ms. Baker's left hand tested against Chris Melton's pubic hair?
Well, the characteristics of his hair are dissimilar than those of Tara Baker's hair.
Please.
Are you asking me that there should have been a recorded statement saying that the hair was eliminated, as opposed to my testimony today that it is not similar to Tara Baker's pubic hair and therefore could not have been his?
The question I'm asking is whether the pubic hair found in Ms. Baker's left hand was tested against Mr. Melton's pubic hair. And if you can, yes or no?
It was not similar to the pubic hair from her left hand.
That doesn't answer my question is, and maybe I'm saying that wrong, please forgive me. And if you can answer yes or no for me, please do so. You had Mr. Melton's pubic hair, is that correct?
Yes.
Okay, and pubic hair was found in Ms. Baker's left hand, is that correct?
Yes.
Okay. Was that pubic hair of Mr. Melton's ever tested to see if it was the pubic hair in Ms. Baker's left hand?
It was indirectly eliminated because a comparison of the knowns also took place to know what their characteristics are, and they were not found to be similar, so it could not have been consistent with the hair from the left hand.
Is that a no?
Sorry?
Is that a no? Is the answer to my question a no?
The comparison does not have to be a direct comparison. The characteristics of the two known samples are not the same, so they both can't be consistent with the hair that's only consistent with hers from the left hand.
And I thank you for that information. That is great information, but I'm asking you a specific question. To my question, is that a yes or a no? Was it tested?
Yes.
Can you show us the report?
No.
No more questions, Your Honor.
Any redirect, Mr. Yalman-Chile?
No, Judge.
All right, may this witness be excused?
Yes, we ask that he is.
Any objection from the defense? You are free to go, sir. You may call your next witness.
Your Honor, can we approach?
You may. We have an hour. Yes, sir. All right, ladies and gentlemen, believe it or not, we have finished early today. So, particularly the person going out of town, yay. All right, so I'm going to release all of you today, obviously at 1:30, and ask you to return again on Monday at 9 o'clock. Obviously, in the meantime, my instructions continue to apply. Please don't discuss the case with anyone. Don't do any independent research. Don't look on social media with regard to this case if it is on there, or the news if it is on there. All the things that we've discussed. Does anybody have any questions for the court? Don't go to any locations that have been discussed, of course, by any testimony. Anybody have any questions for the court before I release all of you? I appreciate your patience this week. It has been a productive week in terms of a lot of things we've gotten through. I appreciate your patience. I know you go in and out of the jury room a lot. That's certainly common in a trial. But I know that it is sometimes, it could be aggravating for you to get up and get down and get up and get down. I know that. So I appreciate your patience with that. Next week, we're going to hopefully have more of an opportunity to have a normal lunch break. Like I said earlier, you can go outside and stretch your legs and things of that nature. We'll have to see how the timing goes, but that would be my plan. So with the thanks of the court, you're all free to go, and we'll see you Monday morning, 9 o'clock. Thank you. In this courtroom. Everybody gone? All right. Court is adjourned. Thank you. May I see counsel, though, at the bench off the record? Thank you. So give me about
I guess you know what comes across.